Good morning. This is another COVID-19 series, and on this particular one, I'm doing a follow-up to the divorce introduction that I did last week. And this time I'd like to just deal with children, as in children in the context of divorce. I think the first thing to be said is that, as I've repeatedly said in practice to clients, that it's really important to get the children aspect of a marital breakup right. And I know it sounds obvious, but sometimes when a couple are separating, there's so much energy to deal with the actual breakup that the couple can often forget that the long-term effects of not dealing with the children correctly can be much more devastating because it can go on for a long time. So therefore, I think before we start, let's just deal with a couple of terms that are often dealt with or are often discussed when you're talking about children. The very first one is guardianship. And I think the thing to understand about guardianship is that it's kind of an overarching term that covers something like, the management of children, what school they go to, health issues, what kind of career options that you might put them into. So it's kind of more the higher level type of decision making for children. And in the context of guardianship, in the case of a married couple, they're automatically guardians of the children. In the case of unmarried couples, due to recent legislation, there is a change or a shift in the historical position. The historical position was that the mother would be an automatic guardian of the child, but the father would have to make an application for that guardianship, and or the mother could sign a declaration saying that the father was a guardian of the child. That, when I say guardian, I mean joint guardian with the mother. The new regime effectively gives the father an automatic right in circumstances where he has lived with the mother and child for a period of 12 months, and 3 of those months are after the child was born. So that kind of that eases the position somewhat in most scenarios where there's a relationship between the adults, or between the parents, that is. Now, just to finish off on guardianship, obviously any parent can sign off on any automatic guardian. So in other words, the mother in most instances can actually voluntarily sign a declaration saying the father is joint guardian, and that doesn't require court application. You can also have a situation where you can make an application to court for guardianship, and that is usually grounded on principles that are set out in the legislation, which are basically that there's a relationship between the person making the application and the child. The new legislation kind of broadened out the number of people, or the range of people that can apply for guardianship. And also, as a kind of an interesting add-on to that, it introduced the concept that where there are no parents of the child alive, that in those circumstances somebody who has the day-to-day care of a child can make an application for guardianship. And just for completeness, in the case of grandparents, it used to be that there was a 2-step application process for contact with the grandchildren. And again, sorry, I'm jumping into the area of contact as opposed to guardianship. But just to deal with the legislation actually introduced a 1-step approach that you can make an application for access to your grandchildren. And just one final point on the new legislation. The new legislation also introduces the whole concept of penalty for a parent who isn't blocking access, or as far as the court is concerned, isn't facilitating access, by kind of introducing a monetary kind of mechanism whereby there would be fines, and or you might have to lodge a sum of money in court as a kind of a security or surety for the access. But anyway, that's me jumping ahead to access, but just to round off in terms of the legislation. In terms of terminology, the other one is custody. Custody, again, is kind of a very difficult one to explain, because normally people think of custody of having the day-to-day care of the child, But I think it's more to do with the fact that for the period of time that the child is in your custody, as in your physical control, that in those circumstances, that's what you're talking about in terms of custody. So custody, usually in the case of parents who are married, you have joint custodians, and that's an automatic that married parents are joint custodians of the children. You can often have a situation post-separation that there's an application by one of them to have sole custody of the children. Just as an observation, by and large, there's rarely a change in that situation. In the case of unmarried parents, again, it would be unusual to have a situation first of all, you wouldn't have an automatic joint custody by both parents. If one of the parties were looking for joint custody, that would be an unusual application insofar as it would be rare enough that would be sought, because, and the reason for that is the third category is access, and access is usually just giving a parent the right to see the children for a certain period of time, and that's guardianship, custody and access. Very hard to say any more about it other than the fact that obviously the overriding principle as far as the court is concerned is the best interest of the child. So the court, if you're in a situation where you can't agree access and or custody, well, access particularly, in those circumstances the court will make the decision. If they make the decision, that decision is to be grounded on the best interest of the child. Another interesting add-on to the recent legislation, that's the 2019 Act, and that is that in the case of children, you're looking at a situation where the voice of the child has to be heard, and if the child is 12 years or more, then the court must take into account the voice of the child in those circumstances. Now, it's no more than take into account the voice of the child. It doesn't make that voice overriding, if you know what I mean. Now, the other, just to finish off on terminology, the other one that we commonly come across is called the primary care. And I think primary care isn't a legal term per se, in that it's not used in legislation as such, but it's commonly the person who, if you like, has the main responsibility for caring for the child on a day-to-day basis. And it's often used, rather than getting into the whole area of custody and access, you would have primary care and visitation rights, if you like. So just to wrap up on that, the end of guardianship, custody and access, or the way to arrive at a conclusion on that, is to see how it might be approached in the event of a breakup. And my suggested mechanism for people dealing with children, I think, is to deal with it by way of a parenting plan. And a parenting plan, and you do have various kind of formats for dealing with parenting plans, but the parenting plan basically is a document that sets out the how to deal with the parenting of children post separation. So a parenting plan, and by the way, a parenting plan can be negotiated through your solicitors and or can be dealt with through mediators. Again, it's a question of trying to facilitate an agreement by the parties for the future care of the children. So it covers all of the usuals that you might expect, week to week, summer, Easter, midterm break, holidays, birthdays, christenings, special events, etc., etc. Birthdays, of course, being the other one. So it tries to cover all those situations. But what it also does is it also tries to cover the how one will communicate with each other, how one parent will communicate with another, and how they will deal with potential conflictual situations, which I think is a fairly common sense approach to it. And the thing, of course, to bear in mind, I believe, is that by going through the process of formulating a parenting plan, it gives a couple an opportunity to focus on the best interests of the children, and also gives them some sort of guidelines to deal with that and kind of pose red flags that they can try and preempt. And always a very good idea and a very good suggestion. And the thing to remember, of course, is that it is often a very efficient way of dealing with it rather than be dealing with it on a as-you-go basis. Bearing in mind, of course, that it may have to be revised, reviewed and checked again as the children get older. So just to wrap up, when dealing with children, my suggestion is that you have a parenting plan. I think you should use a third party to facilitate arriving at that parenting plan. I think that it's very important that you bear in mind that it should be revisited as the children get older. And finally, if there's an issue around guardianship, if part of the process is agreeing guardianship, I think it should be done by declaration rather than by court application. Again, this is John Lynch of Lynch Solicitors, and thank you very much for listening to me.